Welcome to International Trade Minute, Quick Fire Trade News, the essential podcast for today's trade professionals, presented to you by Rydell Law Firm. If you're a seasoned practitioner, this is where you'll find your weekly distilled briefing on the pulse of international commerce and regulation. We bring you the latest legal and trade news, distilled into straightforward, bite-sized updates for busy trade professionals. Sponsored by Rydell Law Firm, this podcast is crafted by expert trade attorneys to keep you ahead of the curve with concise, actionable insights. Perfect for your morning commute or coffee break. Stay informed without the fluff. Subscribe now on Apple Podcasts and Spotify, and join our professional community on LinkedIn. Today, we are exploring a range of critical developments in international trade. We'll dive into the recent halting of DJI drone imports by U.S. Customs and Border Protection, examine the potential risks hidden in Treasury's new outbound investment rules, and discuss the significant settlement reached by RTX over alleged violations. We'll also look at the evolving trends in CFIUS mitigation agreements and their implications for investors. Finally, we'll break down a recent Fifth Circuit ruling on the IRS definition of importer. Let's get started. First up, in a significant development for the drone industry, U.S. Customs and Border Protection has halted imports of certain DJI drone models. This action stems from concerns related to forced labor under the Uyghur Forced Labor Prevention Act. DJI, the world's largest drone manufacturer based in China, has faced scrutiny from U.S. authorities. The company has been classified as a Chinese military company by the U.S. Department of Defense, adding to the complexity of this situation. The CBP's move underscores the ongoing tensions between the U.S. and China, particularly in the tech sector. It also highlights the broader scrutiny of Chinese-made products and their potential national security implications. This development poses challenges for DJI, which supplies more than half of all drones in the U.S. market. The company has pushed back against these allegations, calling them unsubstantiated and categorically false. For trade practitioners, this case emphasizes the importance of supply chain due diligence, especially when dealing with products from regions with forced labor concerns. It also underscores the need to stay abreast of evolving trade regulations and their potential impact on import strategies. Moving forward, we can expect continued scrutiny of Chinese tech imports, particularly those with potential dual-use applications. This situation serves as a reminder of the complex interplay between trade policy, national security, and human rights concerns in today's global marketplace. Up next, the Treasury Department's upcoming outbound investment regulations are raising concerns among investors and legal experts. These new rules, expected to be finalized by year-end, could introduce significant hidden risks for U.S. investors in China. At the heart of these regulations are notification requirements for certain investments in China's artificial intelligence and microelectronics sectors. While the primary purpose is data collection, the potential uses of this information are causing unease. There's particular worry about what might happen if Congress gains access to these notifications. Lawmakers could potentially use this information to publicly name and shame companies they believe are investing against U.S. interests. This could lead to severe reputational damage and business disruptions, especially for firms with significant U.S. operations or government contracts. Moreover, there's uncertainty about how long Treasury has to act on a notification after it's submitted. This ambiguity leaves investors in limbo, unsure of the potential long-term implications of their investments. The lack of clarity on these issues is making it challenging for investors to plan ahead and mitigate risks. As we await the final rules, it's crucial for companies to stay vigilant and prepare for increased scrutiny of their Chinese investments. Moving on to our next story, RTX, formerly known as Raytheon, has been hit with a hefty fine of nearly $1 billion to settle allegations of violations related to sales in Qatar. The charges include breaches of defense, export control regulations, and violations of the Foreign Corrupt Practices Act. The settlement, announced by the Department of Justice and the Securities and Exchange Commission, involves both civil and criminal penalties. RTX has agreed to enter into 2 deferred prosecution agreements to resolve these claims. The allegations are serious, including accusations that Raytheon failed to report bribes in export licensing applications and submitted false information to the U.S. government as part of multiple foreign military defense contracts. As part of the settlement, RTX is required to implement several measures to improve its compliance procedures. These include hiring independent compliance monitors for a 3-year period, putting in place improved sales controls, and bringing on board subject matter experts to oversee its anti-corruption program. The company must also introduce data analytics tools to enhance third-party monitoring and develop a comprehensive communication strategy to improve its ethics and compliance training. This case serves as a stark reminder of the severe consequences of violating export control and anti-corruption laws. Trade practitioners should take note of the increasing scrutiny on international defense sales and the importance of robust compliance programs. For our next news, the Committee on Foreign Investment in the United States, or CFIUS, is ramping up its use of mitigation agreements as a condition for deal clearance. These agreements are not only becoming more prevalent, but also growing in complexity, presenting heightened compliance risks for investors. Former DOJ official David Platinsky notes that while CFIUS still clears most deals, there's an increasing trend of requiring mitigation agreements, particularly in sensitive industries like advanced semiconductors or those involving personal data. This shift means investors need to be more vigilant and prepared for potential mitigation requirements when entering deals. The complexity of these agreements is raising concerns about compliance. More intricate terms make it challenging for companies to avoid even unintentional breaches, potentially exposing them to penalties or other consequences. In light of this trend, some companies may start to reconsider certain bidders if there's a higher likelihood of facing stringent mitigation requirements. While CFIUS review might not be a deal breaker, it could influence seller decisions when weighing bids from different parties. Adding to the evolving CFIUS landscape is the ongoing review of Nippon Steel's acquisition of U.S. Steel. This case has sparked debate about whether CFIUS might be veering from its traditional national security focus towards more politically motivated reviews. While some observers view this as a potential shift in CFIUS's approach, others, including Platinsky, see it as an outlier rather than a new trend. As CFIUS continues to adapt its practices, investors and companies involved in cross-border transactions must stay informed and prepared for increasingly rigorous scrutiny and potential mitigation requirements. Last but not the least, in a recent ruling, the Fifth Circuit Court of Appeals has made a significant decision regarding the definition of an importer under IRS rules. The court rejected a broad interpretation of the term, which could have far-reaching implications for companies involved in international trade. The case centered around Texas Truck Parts and Tire, a tire retailer that purchased tires from Chinese manufacturers. While the court narrowed the definition of importer, it still held Texas Truck liable for excise taxes on the imported goods. The court's decision hinged on the concept of beneficial ownership. Although the Chinese companies physically brought the tires into the United States, the court determined that Texas Truck was the true beneficiary of the imports. This ruling emphasizes that the party deriving the primary benefit from imported goods may be considered the importer for tax purposes, even if they're not directly handling the logistics. This decision provides clarity on how the IRS may interpret importation in future cases. It suggests that companies can't avoid tax liability simply by having foreign suppliers handle the importation process. Trade practitioners should take note of this ruling when structuring import arrangements and advising clients on potential tax implications. As we wrap up today's episode, let's quickly recap the key points we've covered. We discussed the halting of DJI drone imports due to forced labor concerns, potential risks in Treasury's outbound investment rules, RTX's significant settlement for alleged violations, the increasing complexity of CFIUS mitigation agreements, and a notable Fifth Circuit ruling on IRS importer definitions. These developments underscore the ever-evolving landscape of international trade law. Thanks for tuning in to International Trade Minute. We hope you found today's episode insightful and useful for your practice. Remember, our podcast is brought to you by Rydell Law Firm, your trusted partner in navigating international trade law. Don't miss our next episode. Subscribe now on Apple Podcasts and Spotify. Stay connected and continue the conversation with us on LinkedIn. Until next time, stay informed, and stay ahead.